Hello, everyone. Good to see you again. So in this segment, I'll be continuing with the discussion of the Form I-130. Today, I'm going to be discussing the various parts of the Form I-130. And as I said, the Form I-130 is a 12-page form. It's divided into 9 parts. So if you're using an attorney, the attorney will complete the part before Part 1. Part 1, it's all about the petitioner's relationship to the beneficiary. So whether you're the son, the spouse, the brother, the sister, there's a time for you to identify that relationship. Part 2 is the petitioner's information. That is the residence history, the employment history, and the marital history. Part 3 is the petitioner's biographic information. Part 4 is the beneficiary's information. So where the beneficiary will be applying for either the adjustment of status or the immigrant petition. Part 5 is the other information. That's if you have previously filed this petition for the beneficiary or for some other person. Part 6 is the petitioner's statement, the declaration, contact information, and the signature. Part 7 is the biographic information. Part 8 is the interpreter's information. And Part 9 is additional information. So in completing this form, it has to be consistent and be complete as well as accurate. Try especially to complete the questions, and if it's not complete, you don't want immigration sending your application back or rejecting your application. So be careful when you're completing that application. So I've received a few questions regarding the Form I-130, and I'll be willing to discuss and share the answers to those questions with you, and also encourage you to contact me if you have additional questions. So the first question I have is, how many Form I-130 petitions can I file? So the answer will be, you can file as many Form I-130 petitions, but you have to make sure you're filing for eligible relatives. So let's say you have 5 siblings. You can apply for all 5 siblings at the same time, but then you have to meet up with the financial requirements. For each sibling, you have to file a separate Form I-130. And so the answer is yes, you can file more than one Form I-130. The next question is, can I file I-130 Form I-130 while abroad? And the answer is, it depends. Mostly, yes, you can file the I-130 here in the United States, even if you're abroad or outside the United States. But there are some exceptional situations where the Form I-130 can be filed outside the United States, and this is at the U.S. consulate in your country. But I advise you to have a lawyer advise you on that, because it does not apply to everybody, and there is a process for doing that. So yes, it is possible to file that at the embassy, but then you'd want to make sure you're using a lawyer or you're making the proper inquiry. The next question is, does the approval of Form I-130 mean that my relative is a permanent resident? And the answer is no. Your relative is not a permanent resident because he or she received an approved I-130. Rather, Form I-130 approval just means that you have satisfied USCIS that your relative is indeed your relative, or your spouse is indeed your spouse. But there are certain situations where United States citizenship will ask you for additional information because they're not satisfied that this person is your relative. So The mere approval of an I-130 does not mean that your relative has a green card. Rather, it means that your relative can now apply for a green card. The next question is, will my relative be required to appear for an interview? So the answer to this question will be, it really depends. And it will depend on where your relative is filing from. If your relative is in the United States and you're filing just the I-130, sometimes, yes, you may be subjected to an interview. If USCIS has any doubt, but if your relative is outside the United States, you may also be subjected to an interview. Your relative may be subjected to an interview, and that's where the consular officer or the consular office has any doubts. So in some scenarios, you can have the USCIS contact you to attend an interview just for the I-130. But I know that for the most part, for most people who are in the United States, they file their I-130 with the adjustment of status application. So sometimes you have those interviews combined, or sometimes they're separate. So the answer to that is it will depend. And yes, it is possible to have an interview for the I-130. The next question is, what if my relative, who is the petitioner, dies? What options do I have? So yes, that's a possibility. If your petitioner, that's your relative, the petitioner, dies during the process, it really depends on how far along you are in the process. Meaning it could be either that your relative died immediately after filing the I-130, but before it became approved, or your relative died after the approval of the I-130. For either of these scenarios, yes, your I-130, under the law, usually it will be that it's automatically revoked because the person who petitioned for you is no longer there. However, there are scenarios and exceptions and strategies for reinstating that I-130. So it'd be best to contact an attorney to see what your options are. So the next question is, if my status changes from lawful permanent resident to U.S. citizen, what should I do? And the person referenced that he's applying for a relative outside the United States. So if your relative, if you're a lawful permanent resident and you filed an I-130 for your relative who is outside the United States, and after filing that I-130, you became a citizen. So you have to notify the USCIS. And if after filing the the I-130 for your relative, it became approved and you became a US citizen, you still need to inform the National Visa Center. So I always try to contact an attorney to let you know which option or what you should do. But the option you should not explore is just keeping quiet or not doing anything, assuming that USCIS will easily update that. Now you should need to take action. So what if the petitioner and beneficiary divorce? Yeah, unfortunately, yes, that happens. So if the petitioner and beneficiary get divorced, maybe after filing the I-130, that I-130 may be revoked. And again, it will depend on where they are in the process, with the process. So because the petitioner is filing the I-130 based on the marriage, and the marriage is no more, then yes, it will make sense that the I-130 may not also be available. But again, it's always better to contact an attorney, especially if after the couple, that's the petitioner and the beneficiary, get divorced and the petitioner remarries somebody else or the beneficiary remarries somebody else. So it's best to always contact an attorney to find out what strategy or what options are. So what if my Form I-130 is denied or revoked? Are there options? Yes, there are options. And those options are what you can discuss with your attorney, because each case is different and you'd want to make sure that your attorney knows the whole story before advising you. So yes, there are options, and an attorney will give you a best strategy or best options in those kind of scenarios. So I have a few other questions, and I'll take one more question. And that's for children. My child was unmarried at the time I petitioned for him, but he's now married. What do I do? Okay, so if you're petitioning for your child who is unmarried, whether as a US citizen or a lawful permanent resident, and there are changes, yes, things happen, especially if you're a lawful permanent resident. It takes so many years before, the visa number becomes available. You'd want to make sure that that information is shared with your attorney, because there's certain steps that need to be taken. So if you are applying for someone based on the fact that that person or the son or daughter is unmarried at the time of petition, that person is given a visa category based on that status because you're unmarried. So if you become married, you really should not be in that status. And this is something you have to discuss with an attorney to be able to let you know how to go about that process. But action needs to be taken. So that will bring me to the end of this segment on the I-130. And I would thank you for tuning in, and would welcome any feedback you have or questions you may have regarding the Form I-130 or anything in immigration. I look forward to answering those questions. So thank you for tuning in, and if you have questions, don't fail to contact me at 713-730-2900. And as always, please don't forget to subscribe to Tempo Afrique. Thank you. So do we start? Hello, everyone. Welcome to Premium Law Access. Thank you for tuning in. Today, the topic today is a practical guide for completing Form I-130. My name is Uche Nwaneri. I'm an attorney. For those who do not know me, I'm an attorney and co-founder of Premium Law Firm. We are an immigration law office, and we assist clients within and outside the United States who are interested in the U.S. immigration laws. The presentation today will be for only informational purposes only. If you feel that you have additional questions after the presentation, or you have legal questions, please feel free to contact me at 713-730-2900. So we can now start. So what is a Form I-130? A Form I-130 is an alien relative petition. So what does this mean? It's just a petition between which a petitioner will file for a beneficiary, and that's your relative who is planning to come to the United States to live permanently. So it's a petition to establish the existence of that relationship. So you, the petitioner, will be petitioning for your relative who is the beneficiary. And I-130 does not confer a green card status, but does not mean that when it is approved, you have a green card. But what it does mean is that it establishes that you are either the spouse, the child, the parent of the petitioner. It just establishes the relationship, and that's it. So when it is approved, it then allows you to apply for your green card. And this will depend on where you are applying from. If you are in the United States, it'll be the adjustment of status. If you're outside the United States, it will be by consular processing, and that's by filing an immigrant application. So having said that, the next question will be, who is a petitioner? So a petitioner can be a United States citizen or a lawful permanent resident. And the petitioner will usually file for a beneficiary. So who is the beneficiary? A beneficiary will be an eligible relative. So I guess the question will be, how do I know if my relative is eligible? So to that, I will divide that into two groups. You'll have the beneficiary of a United States citizen and the beneficiary of a lawful permanent resident. For the beneficiary of a United States citizen, they're divided into two groups. The first group is the immediate relative, and an immediate relative usually are the spouse of the United States citizen, the unmarried child under 21 years of the United States citizen. And if the United States citizen is a child who is 21 years and older, wanting to file an immigrant petition for the parents, that child has to be at least 21 years. So these are the immediate relatives. So the difference really between an immediate relative and the second group, that's the preference category or preference relatives, are essentially about the availability of visa numbers. For the immediate relatives, immigrant visas are always available. For the preference relatives, they have to wait till an immigrant visa becomes available, and this will depend on when they file. So for the preference categories, there are usually about 226,000 visas available in a fiscal year, a minimum of that in a fiscal year. But the immediate relatives are not subject to that limitation. So now, who are the preference relatives? The preference relatives of the United States citizens are, one, the unmarried, we'll call it son and daughter, of a United States citizen who is over 21 years and older. You also have in that category the married son and daughter of a United States citizen of any age. Also in that category are the brother, or it's either the brother or sister, or brothers and sisters of a United States citizen. So all these are the preference categories of the United States citizen, and all these are those the United States citizen can petition for. So having said that, we'll now go to who are the beneficiaries of the lawful permanent resident. So first off, it has to be an eligible relative. So the permanent resident, lawful permanent resident, can petition for his spouse, his or her spouse. He or she can also petition for his or her unmarried child under 21 years. And he or her can petition for the unmarried child who is 21 years and older. So these are the three groups the lawful permanent resident can apply for. So you'll notice that I did not say anything about immediate relative when it comes to permanent residents, the lawful permanent residents, because no, they do not have lawful permanent, they don't have immediate relatives to petition for. It is only the United States citizen who can petition for an immediate relative. So what does that mean? It means that the lawful permanent residents, if you're applying for your family members or your relatives, you have to wait for a visa number to become available before they can adjust status. But you can always apply for the I-130, which is to establish the relationship. So that's where you'll always want to start. So having said that, I will now go over those who cannot become eligible relatives. So those whom the United States citizen or the lawful permanent resident cannot apply or petition for, that's file an I-130 for. So this group are as follows. One, you have the grandparents, you have the grandchildren, you have the uncles, you have the aunts, you have the nieces, you have the nephews, you have the cousins, you have the parents-in-law. You also have the brother and sister of a lawful permanent resident. You also have the parents of a lawful permanent resident. And you also have the married son or daughter of a lawful permanent resident. In addition to these groups, if you're filing for a stepchild and you're a U.S. citizen, you want to make sure that the marriage between you and your spouse took place before that stepchild turned the age of 18 years. If that child is over 18 years, you cannot petition for that child under the I-130. Also, if you are applying for an adopted child, you'd want to make sure that you file the petition before you adopted that child, and that child would have been less than 16 years before the adoption. So these are groups where you cannot apply for I-130, or you can petition for I-130 for any of these people. However, sometimes exceptions apply, and that you'll have to contact an attorney to see if there's any way or if there are exceptions that may apply in your situation. So having discussed that, I will now go over on how you can apply for a Form I-130. So the two ways of applying for a Form I-130 are: one, you can apply for the I-130 by itself, or you can wait for the approval of one of the I-130 before applying for the adjustment of status. So what does this mean? It really depends on where you are applying from. If you are applying from the United States, in some situations, you can apply with your adjustment of status application. That is, you can file those concurrently. However, if you are applying, if your relative is outside the United States, you can now apply starting with the I-130, which has to be approved first before your relative can now apply for the immigrant visa or immigrant application. So those are ways of applying for the I-130. Now, if you are in the United States and you are married, or you are planning to file for your spouse, in addition to the I-130, you also have to file the I-130A, I-130A. So that is for your spouse. You have to file. It's only for those who are filing for their spouses. Before you file, there are also additional documents, required supporting documents you need to file along with your petition. So make sure that you're filing those. If you're doing that yourself, or if an attorney is doing that, the attorney will know what to do. So that's it about how to apply for the I-130.